Yes.
Lordship, in item number 4, dinner will be in court number 1, Lordship. Can it be taken after some time, Lordship?
Item 4.
Yes, Lordship.
Okay.
May I please, Lordship? Lordship, I beg to mention, 12 and 13, my senior is out of station.
Item number
12 and 13.
12 and 13. You'll have to wait till the matter is called. These are 2019 matters. Please wait.
May I please, Lordship? I beg to mention for listing the motion matter.
Listing given to the court.
Yes,
Let him come.
Daily list item 1 for motion.
My lord, in this case, I have received.
Item 1 for motion.
Lordship, in this case, I have received the instruction. He has been pushed back in the intervening night of 26 or 27 May 2025.
25.
He was arrested on 24. 24.
Two brothers picked up on the same day.
It was okay.
His name is a serial number
39.
his his area of responsibility of 157 battalion would be where?
Lordship. E7. I just make a call.
Officer. Yes, item two.
Item two.
You got a copy of the resolution? Sharma? Mr. Sharma, you got a copy of the resolution? Last time the FI was not matching at page 16.
Last, RB Gora was there, whether she got or not, whatever thing.
You're giving him a copy.
Yes, Lordship, I have already given.
Page 16, which is there in our brief, was not there with you.
Yes.
On the last occasion. You have a copy now?
Yes, suppose. Officer in charge.
So we issue notice then,
Yes.
what is that presented? Stamp cycle and counsel for the petitioner submitted that a copy of the fire at page 16, which is referred to in the order dated 31/3/2016, has been furnished to the government advocate. Next one. It is projected in this writ petition filed under Article 226 of the Constitution of India that the police personnel had made an illegal search at their house at around 1 AM without following the due process of law. And brought the husband and brother of the petitioner without due process of law. Next, for review of the allegations. Court is in time to issue notice returnable on they have not been released. They have not been released.
Yes, Lordship, I have already released one.
Hmm?
Accused number two, petitioner number two, who is the accused, Lordship, he was released by the intervention of this honorable court, bail order. Now, Lordship, seized article, Lordship, has not been released. In this case, Lordship, the seized article, Lordship, which has been not released, Lordship, at the time of seizure, Lordship, procedural defect has been made by the investigation team, Lordship, headed by Chinmoy Borua, Lordship. In the event, Lordship, my house has been searched, Lordship. We are living in a joint family, Lordship, at around approximate 1 AM, Lordship. Even also without assistance of the local police personnel, Lordship.
That we have already issued a notice. You were
Yes.
saying about seized articles. Please complete that part. What is your summation on seized article?
Yes, lordship, seized article, that is the gold item, article which has been seized from the business establishment also, located at Lanka lordship. For this lordship, my two pair lordship, one is that for release the seized article, and one under the is the initiate investigation, initiate disciplinary proceeding against the investigation officer lordship, not follow the mandatory provision of law. Even also lordship, at the time of arrest, lordship, ground of arrest not been communicated to the family member of the accused petitioner in this case. Lordship, issue notice, lordship, and call for it. Your Lord.
I'm asking on the release matter.
To do after that, articles were seized, did you move the trial court or the CGM court for the custody of the items? We don't find any
It
statement
is
here.
absolutely right, lordship, but honorable press court is a very much clear, lordship, wherein procedural defect has been made, lordship, by the investigation team, lordship. It will be maintainable, lordship.
Yes, correct. One of the prayers in the writ petition is with regard to release of the seized articles.
Yeah, only that's what we want.
This court, in the case of, with that, I'll give you later on, case of so and so, has held that if the articles, seized articles are part of the required, part of this investigation, the same cannot be released in exercise of power under 317 and 371 of the CRPC. To stop. Whether there is no statement in this writ petition as to whether the petitioner had moved the trial court or the court of first instance, i.e. the court of jurisdictional magistrate for return of the seized articles, comma, the prayer for release of seized articles in this, made in this writ petition is hereby rejected. Next paragraph. However, in the affidavit to be filed by the respondents, they will indicate as to whether there's any requirement of the seized articles to be retained for the purpose of further investigation. Next paragraph, notice is made returnable on how much time do you need?
Based on 4 weeks time.
4 weeks take too long, is a habeas corpus, they were sorry, the criminal writ petition. 13th of May.
Yes.
In May. Bharat, Mr. P. Sharma, an additional senior government advocate, we served with requisite extra copies of the writ petition as he accepts notice on behalf of all the respondents.
All that's not.
Next one, the senior government advocate is also requested to send a download of this order to the respondents so that they would file their response without fail. Next one, is from 13/5/2026.
I'm obliged.
Lordship, it is in Kakribadi, district Kuch Bihar, West Bengal. Kakribadi, district Kuch Bihar.
So we close the matter with, whatever video is available for you once he's sent back. There's nothing that can be done now.
My simple question is, there is no any agreement with the Bangladesh Miller. And there is no any also extradition treaty Miller. In the last,
Extradition is not required for a illegal foreigner. Extradition is required for
then
people.
Miller state government also take illegal action Miller.
Pardon me?
He has in the petition of Father Miller. There is no any agreement Miller with the Bangladesh and in India Miller.
That is for the government to do. You can agitate the matter against the government. But in this writ petition, we can't recover. You see, an agreement is not required to send a person back. Let us say for a person from X country X is found in Assam without any legal document. Cannot the government of India send him back to his
At
country?
that part Miller, Bangladesh also, they may be accepted the person Miller,
We
whom
don't
the
know about
India
that.
government is pushed
That is
back
something
Miller.
we can't answer.
That is the problem, whole problem is arising.
Can't help it. He is a declared foreign national in 2015. The order was not ever put under challenge.
That is the
Extradition
whole
is
problem.
done only when the person has fled away from the country to bring him back. Extradition request has not come from Bangladesh. So therefore, principle, the argument of the argument you are proposing of extradition is misplaced here. They are not sending by way of extradition. Bangladesh government did not send any request to send this man. So this is extradition will be required only when the country, which is Bangladesh, sends a request.
There is no any information where about the petitioner's father Miller till today Miller.
From Bangladesh, government can't give you.
Whether the petitioner's father is exist or not, there is no any information. From the
So we don't even know. He may be again back in your house.
back him till that Miller, sometime back Miller.
We understand. You see,
There is no
for
any.
few things we don't have an answer.
Yes, yes Miller.
So. But Mr. A.M. Ahmed, for the petitioner, also heard Mr. S.S. Roy Leonard, CGC, appearing for the respondent number
8.
8. Others will come earlier. Mr. For foreigners tribunal, who is there?
Even man.
Okay, I have Mr. Ms. A. Verma, standing counsel for KFT and border matters, appearing for respondent number 1, 2, 3, 5, 6, and 7. Mr. E. Sharma, an additional senior government advocate for respondent number 4. You've been added as 8.
Yes.
So, just for analysis, correspond with 8. By filing this habeas corpus petition under Article 226 of the Constitution of India, the case projected by the petitioner is that his father, Mahib Ali, M-A-H-I-B, Ali, was illegally taken into custody and detained since 24/5/2025 by the police personnel from Golaghat from his residence without communicating to the petitioner the grounds of arrest and without service of any notice. And since then, the whereabouts of the father of the petitioner is not known. It is projected that the family members of the petitioner approached the concerned respondent authorities number 5 and 7, i.e. the Superintendent of Police Golaghat and the officer in charge of Golaghat Police Station, to know about the whereabouts of the detained person, but no reply was given. Accordingly, apprehending that something wrong has happened to the detained person and he is not safe, the present writ petition in the nature of habeas corpus has been filed for production of the said detained person. Next paragraph. It is also projected that after the father of the petitioner was taken into custody, the petitioner and other family members came to know that an ex parte opinion dated 22/6/2012 was passed by the learned member from a foreigners tribunal Golaghat in case number so and so, page 30. Case number so and so, so and so and so and so. Next one. The matter was, the writ petition was filed on 15/9/2025, but owing to certain defects, the reporting could only be done on 2/12/2025, and thereafter the matter was listed on 3/12/2025, and the learned counsel for the petitioner was required to serve copies of the writ petition to the learned counsel for the FT and border matters. And accordingly, when the matter was listed on 5/12/2025, the court requested the learned standing counsel for the home and FT matters to inquire about the whereabouts of the petitioner and to father of the petitioner and to inform the court. To stop. And the matter was listed on 10/12/2025, the learned standing counsel for the FT and border matters produced a copy of written instructions dated 9/12/2025, informing that the detained foreign national, namely Mohammed Mahib, M-A-H-I-B, Mahib Ali, against whom opinion dated 22/6/2012 was passed, had been handed over to the Border Security Force, sector headquarters, Panbari, on 26/5/2025. Accordingly, we had requested the learned CGC to obtain instructions. On 15/12/2025, when the matter was listed, the learned CGC has informed the court that pursuant to the said opinion, the said declared foreign national was sent back to Bangladesh. Accordingly, the matter was adjourned to enable the learned counsel for the petitioner to obtain instructions. On 28/1/2026, when the matter was listed, the learned CGC had paid for 2 weeks' time to obtain instructions. In the meantime, pursuant to order dated 17/2/2026, passed in IS Civil 438 of 2026, the Union of India was imperiled as respondent number 8. And accordingly, the matter was ordered to be listed after the amended cause title is filed. Thereafter, the matter was listed on 6/4/2026, and the learned CGC was directed to obtain instructions as to how the declared foreign national, namely Mohammed Mahib Ali, M-A-H-I-B, Mahib Ali, was sent to Bangladesh. Next, accordingly, the learned CGC has produced a copy of written instructions dated. What is the date here? 3/4 or 13/4? Should be 13/4. I can't read it. This. You see the original one? If you can make it out. Yes. I can read it. 20. Dated 20/4/2026. Inter alia, stating that the declared for national Devli Muhammad Mohib Ali, son of late Derajuddin Ali, Derajuddin Ali, whose name is mentioned at serial number 39 of the enclosed list, was sent back to Bangladesh from the area of responsibility of 157 Battalion, BN Battalion, BSF, on the intervening night of 26/27 May 2025. Full stop. Next para. On the request of the court, the Lanet CGC has obtained telephonic instructions stating that the declared foreign national has been sent to a location in or around Katibari, Katibari, in the district of Coach Bihar from West Bengal. Next part. The learned counsel for the petitioner has submitted that the manner of sending back the declared foreign national to Bangladesh is questionable, as there is no extradition treaty between India and Bangladesh to send back the declared foreign nationals. So it is submitted that the petitioner apprehends the safety and well-being and health condition of his father, he also questions as to whether the authorities in Bangladesh have accepted the father of the petitioner as in their territory. Next. In this regard, the court is of the considered opinion that as the petitioner was declared to be foreign national by opinion dated 22/6/2012, passed by page 30, his status would be that of a declared foreign national. Accordingly, irrespective of whether there is any agreement between the two countries to send back a declared foreign national, but the state would have the power and authority to send back a declared foreign national out of the country. And in this case, the instructions are produced to show that the father of the petitioner was sent back to a particular location in the district of give that name. Particular location is that so and so, in the district of Coach Bihar, West Bengal. Therefore, the principle relating to the extradition of a person would not arise in this case, as there was no request from Bangladesh to extradite the father of the petitioner. Therefore, once the declared foreign national has been sent back to the specified territory, it is not for this court to issue any directions to the Union of India to obtain further information as to the declared foreign national. Therefore, the issue regarding the health and well-being of the declared foreign national would not now be a responsibility of the government of India. Next, accordingly, without prejudice to the right of the petitioner to seek the petitioner or the declared foreign national to seek any remedy as to as they may be so advised, in view of the sending back of the declared foreign national to his to the specified territory, nothing survives in this writ petition, and accordingly this writ petition stands closed. Full stop. The instructions produced by the CGC is kept as a part of the record.
For delivery of judgment, item 21.
There is no representation from the petitioner side, but I'm saying the petition is dismissed mainly on the ground that the petitioner could not establish the link with his parents and the grandparents because she could not produce any voters list with her name together with them. And the other ground that the Gaupura certificate and the Panchayat certificate, those were not proved because they were not called as witnesses. And the third ground that we wanted remand of the matter because the tribunal has questioned him. That also goes because the tribunal can always put questions under one system. So on these grounds, basically, that is.
Item 3 for motion.
We did not hear you. Please repeat again. Last order. Okay. You've got the information. You got the information.
Yes.
On the last date, on the submission made by the learned counsel for the petitioner, we recorded that the petitioner projects that the husband was taken into custody and their whereabouts are not known. Accordingly, we request the learned standing counsel for the FT matters to obtain information as to the place where the husband of the petitioner, Islamuddin Laskar, is presently lodged, if not already deported. Tomorrow.
So fine.
Okay.
Supplementary item 22 for motion.
Just find out the Laskar has just gone out. No, Mr. Laskar has gone out. Just find him out.
Just go out and
No, Mr. Sharma, please go out and find him. He's just left. People. Hmm? Yes. $85. You'll have to wait for some time. You are some delay in filing.
Not to deport. My information is not. Final order lordship, 18 February 2021.
And Mr. Sharma, he's 69 years as per the affidavit. He did not fail.
SP forward.
third Mr.
N. Ahmed.
N. Ahmed, learned counsel for the petitioner, and Mr. Sharma, the learned standing counsel. is
FTN border matters as well as NRC.
learned counsel appearing for FT and border matters.
As well as NRC.
By this application, the petitioner has challenged the order dated 18/2/2025 passed by the learned member, page 85, writing numbers. So and so, by which the petitioner has been declared as a foreigner of post 25/3/1971 street. Issue notice returnable by so and so. Okay. Extra copies to be furnished, the learned counsel appearing for border and FT matters by the petitioner within a period of 3 days from today. The petitioner is petitioner's prayer for bail is although opposed by the learned standing counsel for border and FT matters. But seeing the projection and the and the age of the petitioner. This court directs that the petitioner may be released on bail on furnished of the with the satisfaction of the SP borders, Borgata.
Yes, yes.
Maybe, right. Does this matter?
Within this,
No, within 15 days. We should go.
from the date of.
Does this matter? After 4 weeks.
No.
Give a date. Call for the record. Sentence, nothing.
For admission, item 5 with item 6.
May I presume? There is a two case against me, Your Lordship. The first case is, my lord, 998 of 2026, Your Lordship. This is a contested matter, Your Lordship. Kindly come on page number 48, Your Lordship. Say, between order, Your Lordship. My lord, after declaring me as a foreigner, Your Lordship, thereafter second notice has been issued against me, Your Lordship. I have annexed the second notice also in this writ petition. Second notice on page number 53, Your Lordship.
What instructions?
Lordship. No, Lordship. He shall just come as per positive field. Second note, yes, my lord. Second notice has been also challenged by the writ petition, Your Lordship, 1142, 2026, Your Lordship. My humble prayer is that, Your Lordship, kindly give me some protection and take this matter on hearing. He shall also come and 66, 70 voter list also here, and I have been casted for a minute along with my father, mother. My lord. Yes, my lord. Notice has been,
Which page is that notice?
my lord. Page number 22. Page number 22, particular is on page number 23 also. Same tribunal. Same. There's a protection, and this is has been fixed on, Your Lordship, 30. Oh. Some instruction has been received, Lordship. But My lord.
Is, according to the instructions, these two cases arise out of two separate reference. One is by the border police. The
Yes.
second is the reference made by the electoral registration officer.
Hmm.
Electoral registration officer works under the Representative of the People's Act. So the tribunals or the Superintendent of Police border, they can't stop the reference of the uh, electoral registration officer. So what we are saying is that we are uh, referring to the law laid down on the res judicata,
My lord.
and you will go there and you will have to establish your identity that you are same person. If that is so, you will not be taken into custody, and that on the principles of res judicata, the second proceeding will be closed. But you'll have to prove your identity, that you are the same person.
Yes, my lord. And the second thing is that, my lord, I am belongs from Barpeta district, your lordship. And I am presently residing at Sonitpur as a temporary, your lordship. I am
So that we don't know. We have to go to
Yes,
the
sir.
jurisdictional tribunal.
not a single document has been recovered from Sonitpur. I can. There is no any single documents for me from Sonitpur, your lordship.
No, identity is not proved by residence.
Yes, sir.
Identity is proved by the, by any other document. You see, these names are very common.
All I know. Same is
This, if we search for Kadir Ali, there will be hundreds of people with the same name.
it,
So we can't say whether you are the same person who are the proceeding in two different cases. In the High Court will not enter into that arena of finding out the identity of the people.
I have accepted, my lord. It's the same person, my lord.
No, that's okay, but today we can't vouch for it. Therefore, your identity has to be shown before the tribunal. If they will be satisfied, we give you protection from arrest. They will not take you into custody. And you prove your identity if you are the same person, they will not proceed against you.
But, my lord,
in this WPC 998 of 2026 item, first item, say that as a represented pursuant to orders passed earlier, the records of the tribunal is received. The admission column on item 5 on so and so forth. Items number 6, we say. Heard Mr. S. Islam, the counsel for the petitioner, and also heard so and so for the respondents. Next paragraph. It is projected in this case that the that by opinion dated 5/9/2022, passed by the learned member, Foreigners Tribunal 7th, Tejpur, Balipara, in case number FT 477/2016, then the second bracket, reference number TZP within bracket capital V, bracket close, /08/1367. This you will get in order, page number 48 of item 5. He was declared to be a foreigner of post 25 to 1971 stream. The next, the said opinion was assailed before this court by filing WPC 998 of 2026 and this court by order dated 23/2/2026, passed in the said writ petition, issued notice and on considering the and notice and the records were called for, and the records are accordingly received. Next paragraph. Thereafter, the petitioner is in receipt of another notice issued on 4/12/2025 by the same learned tribunal, IE, Foreigners Tribunal 7th, Tejpur, Balipara, requiring appearance of the petitioner on 21/1/2026 in connection with FT case number DC 1716/16, arising out of SP within bracket border '(S) bracket close, reference number TZP within bracket capital B bracket close 98/1995. It can't be 95. It say 98 oblique 247, 947. 98 oblique 947. Dated 2/7/1998. So accordingly, comma, on the ground that after declaring the petitioner to be a foreigner of post 25/3/1971 stream in FT case number 477 of 2016, the second proceeding against the petitioner would not be maintainable. And accordingly, by filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the notice dated 3/12/2025 issued in the proceedings of DC 1716 of 2016. Pending for disposal before the learned member from Foreigners Tribunal number 7th on Tejpur at Balipara. Next. Pursuant to order past review, the learned standing house for the FT and border matters has produced copy of written instructions dated 25/3/2026. From the Senior Superintendent of Police, Border Sonipur, enclosing therewith the correspondence made by the learned member from a Foreigners Tribunal 7th, Sharidwar and Balipara, thereby informing that two cases were registered against the petitioner. One was the said FT case number 477 of 2016, which arose out of the investigation by the investigation under the Superintendent of Police, Border Sonpur, Tejpur, and the second proceedings, i.e. the present proceeding, that is DC 1716 of 2016, was initiated as a doubtful voter case which was also referred by the Superintendent of Police, Border Sonipur, Tejpur. And accordingly, as it is posited that as both the cases originated out of two different sources, the learned tribunal had to issue notice on the petitioner. Next one. Next one. In the context of the above, the court is of the considered opinion that it would be appropriate to direct the petitioner, namely so and so, to appear before the learned member, foreigners tribunal, Tejpur 7th, Saridwar at Balipara, along with a photocopy of the opinion passed against the petitioner in FT case number 477, opinion dated 5/9/2022, passed in FT 477 of 2016, and to produce his proof of identity, just to by which the learned tribunal shall record its satisfaction as to the identity of the petitioner. And if the petitioner is found to be the proceedings of DC 1716 of 2016, after due inquiry, it would be as the principles of res judicata applies even before the foreigners tribunals, as has been laid down by the Supreme Court of India in the case of Abdul Qudus versus Union of India and others, about 2019, 604, and reiterated and followed by this court in the case of Jahir Ali, JHIR, Ali versus Union of India, 2021, within bracket post 3 GLR 105, equivalent to 2021, within bracket 2, bracket post GLT 596, in the event the identity of the petitioner is found to be same in both the proceedings, the proceedings of FT case number DC 1716 of 2016 shall be closed. Next para. In order to facilitate the appearance of the petitioner before the said learned tribunal, the petitioner is granted 15 days time from the date of the order to appear before the said learned tribunal and to produce his proof of identity. Next para. The learned member, foreigners tribunal, Tejpur 7th, at Saridwar, Saridwar at Balipara, is requested not to arrest the petitioner. Full stop. The filing of the written statement is ordered to be deferred till the identity of the petitioner is till the learned tribunal is satisfied with the identity of the petitioner. Next paragraph, needless to say that in the event the petitioner is still aggrieved by any order that may be passed by the learned tribunal, this matter is kept pending. Next paragraph, list on filed on the same date, huh? I don't know. Next part, the petitioner is permitted to produce a certified copy of the order before the said learned tribunal. So that list on so.
Hello.
Given you protection of from arrest, we have given you protection of not filing of the written statement. You have to prove your identity. You can prove that you are the same person.
Hello, Malad.
Mr. Sharma, to send back this records, otherwise the tribunal will not be able to find out.
Yes.
Huh?
Wonderful.
The last time you said. You facilitated the said learned tribunal. Finish the records of 50 case number 477 of 2016. The registry is directed to send back the records of 50 case number 477 of 2016, which is tracked with the record of WBC 998 of 26. Of the said learned tribunal is requested to return back the record once the identity of the petitioner is established. We make it 1 month.
36%.
So your appearance will be same date. The listing is only different.
Happy May remain fixed. The second notice has been fixed on 30 May only. 30 May. We will find within 15 days.
Next date is
20, 30th
30 May.
30 May, yeah.
But your appearance is 15 days.
Yes, yes. Must be.
For hearing, item 7, part heard.
The last two patients. Yes, this. Last two patients, we have concluded. I will refresh you much. Yeah, 38 years, petitioner husband was picked up. Then thereafter, they died at the hands of the police. Charge sheet has been filed, and charge sheet. Refresh to. Refresh over.
Yes. Recapitulate your argument.
I'll
That was
have to
that-
refresh myself also. In the process. My lord, petitioner husband.
We'll tell you what we think you have argued. You have referred to the incident which happened, and then in order to claim compensation, you are trying to you are projecting that he is the owner of 4 vehicles. He has wife, 2 minor daughters, and 1 minor son. And the victim was 38 years, and you are referring to page 119 to project that his monthly income. At that point of time was
Installment you are paying
59,590, and his accumulated liability was 65,830. And therefore, you are relying on the case of S. Vijay Shankar versus State of Tamil Nadu, claim that this court would be granting exemplary compensation.
In terms of Sarla Billa, MSCT case. Because I refer to the Lordship, if I am not, because the charge sheet, if your Lordship goes into charge sheets, page 80 from 90 onwards. No? 90, 91, 92, 93, 94, 95, up to 96. It will show that all officials are involved. For the death of the petition, there is no ambiguity in that regard. So ultimately, my lord, FIR was filed, it was not registered. PIL was taken up suo motu, and on the basis of the PIL order, my lord, special investigation team was constituted, and thereafter, my lord, charge sheet was filed. That your lordship will, these are the facts. He was picked up on 24/4/20, para 3. And para 2, I have stated, my lord, he's a businessman, owner of 4 vehicles. Monthly installment, he was paying 3,59,590. They have not denied all this, my lord. FIR lodged on 24/4/20. Police did not initiate any action. A letter was sent to the Honorable Chief Justice. Suo motu, my lord, the case was registered. Then thereafter, my lord, your lordship may kindly say page 47. Page 47. Relevant is page 50. By virtue of this order, we direct the special investigation team to conduct investigation in regard to facts and circumstances resulting in arrest, abductions of the victim and his murder in relation to Harangjo police stations, case number so and so, registered on so and so, the relevant penal provisions of the Indian Penal Code. It is made clear that this court would be monitoring the investigation. So ultimately, my lord, the charge sheet was filed on 2/10/21, page 55. And your lordship will get the relevant paragraph from 90 to 98.
Charge sheet filing date is
Dated on 2/10/21.
2020.
Page 90, if your lordship goes through the relevant pages. Brief facts, background of the case. It's a very pathetic, my lord, that her husband was picked up in this manner, put to torture, then thereafter, my lord, put to death. So for the purpose of this case, my lord, need not go into all the facts, my lord, but the facts are very clear that all the police officials are involved in picking up the petitioner, then thereafter, my lord, causing his death.
There are those facts.
My lord, may I read?
The charge sheet, where we find out, which page will find?
Page
out?
90,
90.
90. May I read, my lord? Let me read it.
90, page 90 and 91 are same.
Yes, my lord. No, but second 90 has to be ignored. May I read, my lord?
No, not required. Only anything which you want to specifically highlight.
No, all the police officials are involved. All the police officials are involved, and the charge sheet has been filed. They are facing the trial now. Police, the government has also appointed one special prosecutor. So we filed a case here, and government has appointed the public prosecutor. Your lordship will get page 96, the conspiracy part,
96.
6, conspiracy part. And page 97, tortured, illegal custody of the victim. Page 97, and death of the victim, Santosh Oya.
You have with you, Mr.
Yes, yes.
Goswami? You have with you the records of the case?
No, record is not.
Records will be, the criminal case, records will be in Haplam only. It is in Haplam, criminal case. Records will be in-
No, but in cases where there are deaths, normally the police records are maintained in triplicate and the officer of the
Duplicate
SP
has-
must be having
Yes,
the record.
But my respectful submission is, my lord, this is not the case. That state has not done its part. Negligence is there. That is why the petitioners are before your lordship. That is not the
No, no,
case.
let Mr.
That is only, my
No,
lord, the
let
case
Mr.
of
Das complete.
compensation.
I'm asking you about the case diary only.
If your lordship so directs, we can try to obtain it. But to my understanding, my lord, that is not the case of the petitioner.
I'm not challenging.
If your lordship so directs,
So
my
this
lord,
nature, we are not dependent on the pleadings alone.
my,
We are not also dependent on submission of Mr. Das.
my.
We
All
will
right,
take
in
our
that
own-
case, we'll try to obtain it. Alright. But.
No, no, very okay. Duplicate copy. Very okay. তারপর প্রিন্ট করে দেবো মই জানি কিন্তু ভয় দেখতে পাচ্ছি শুনলাম না আমার ওয়ার একটা লাগিয়েছে স্টেট অফ হরমোন স্টেট অফ হরমোন করছে একটু কমেন্ট ওটা বিষয় তোমার কেমন জানো আমার কেমন জানো তুমি ফেলে বা মনে ফেলে কি হলো ঠিক আছে Yes.
Last occasion, I think we have posed a query and you referred to a judgment.
Yes.
The query of the court was that in various authorities by the Supreme Court of India, in cases of compensation, they have, lordships have laid down that the compensation that can be granted in a writ petition are normally palliative in nature. And therefore, the parties will have to approach the civil court for compensation. That is the query.
The part, court, Supreme Court has said that in this kind of cases, principle of Sarla Verma has to be followed.
No,
I'll
that
take your
is-
lordship again once again.
You see, Sarla Verma, the High Court in first instance will normally not do it. That is in reference to MSCT case.
Yes,
It goes by the tribunal and then comes.
if you have this principle, his age, his family, his income,
No, that
this
is
has
okay,
to
but
be-
which case you cited that the High Court can give compensation? What was that case you cited?
yes, I'll choose. Hello, this charge sheet will show that custodial debt at the hands of the, debt at the hands of the police. So I don't think my record is necessary. So because they have not denied that this is a facts acceptable by everybody. Even
We
the
are
government
confined
is
only
also,
with this, my lord.
government is also has appointed a public prosecutor, special public prosecutor on behalf of the petitioner. So I'll take your lordship to first judgment 2022 minor live law SC 368. As your lordship got it matter.
Oh, that's in maybe
Huh?
this concept.
This one issue.
Well,
Listen to you be there, no?
Judgments are here.
Judgment time. These are victims of fire tragedy, but I will go through your lordship's paragraph 4, subparagraph 64. Very lengthy judgment.
Paragraph, yeah.
64. Paragraph 14, my lord. Paragraph 14, 13. Internal page is 13.
Yes.
Bad example. Paragraph 6. Therefore, what can be awarded as compensation by way of public law remedy need not only be nominal palliative amount, but something more. It can be by way of making monetary amounts for the wrong done or by way of exemplary damages.
Yes.
Exemplary damages. Madam, may I read? Well, let me go through the some important paragraphs of this judgment. Because I think in our court, on the basis of Sarla, there is no judgment, but in other courts, the judgments are plenty. The compensation on the basis of Sarla Verma, that MSCT case, I didn't find any case in our High Court. But in other courts, that I have given Madras High Court and other courts, including Supreme Court, the compensation is based on Sarla Verma. If three components are there. May I read, Mela, that paragraph 14,
Yes.
subparagraph 64, paragraph page 13. I'll read this. Therefore, what can be awarded as compensation by way of public law in remedy need not only be a nominal relative amount, but something more. In our courts, Mela, we always go for palliative amount, then go to civil court. This is what the normal trend in our court is. It can be by way of making monetary amounts for the wrong done or by way of exemplary damages exclusive of any amount recoverable in a civil action based on tortious liability. Insofar as that cases are concerned, the principle of determining compensation is streamlined by several decisions of this court. See, for example, Sarla Verma and so and so. So Sarla Verma is that MSCT case. where it says so now. If three factors are available, the compensation can be determined. The first is the age of the deceased, we have it here. The second is the income of the deceased. We have shown that how much money he was paying. Otherwise, income tax is not applicable to them in view of Section 10 of the Income Tax Act. Deceased. And the third is the number of dependents. We have this to determine the percentage of deductions for personal expenses. For convenience, the third factor can also be excluded by adopting as standard deductions of 1/3 towards personal expenses. Therefore, just two factors are required to be ascertained to determine the compensation in 59 individual cases. First is the annual income of the deceased, 2/3 of which becomes the annual loss of dependency, and second, the age of the deceased, which will punish the multiplier in terms of Sarla Varma. The annual loss of dependency multiplied by the multiplier will give the compensation. As this is a comparatively simple exercise, we direct the Registrar General of the Delhi High Court to receive applications in regard to that cases from the claimants who want a compensation in excess of what has been awarded. So ultimately, it was sent to the registrar and the applications will be given, he will determine the page. Paragraph 96, your lordship, can you see? I'm just skipping. I think next page, my lord, paragraph 1596. Subparagraph 96 of paragraph 15, paragraph 4, page 14. May I read now? Subparagraph 96 of paragraph 15. Courts have held that due to the actions or inactions of the state or its officers, if the fundamental rights of the citizens are infringed, then the liability of the state, its officials and instrumentalities is strict. The claim raised for compensation in such a case is not a private law claim for damages under which the damages recoverable are large. The claim made for compensation in public law is for compensating the claimants for deprivations of life and personal liberty, which has nothing to do with a claim in a private law claim in tort in an ordinary civil court. But in a case where the life and personal liberty have been violated, the absence of any statutory provisions for compensation in the statute is of no consequences. Right to life guaranteed under Article 21 of the Constitution is the most sacred right preserved and protected under the Constitution's violations of which always actionable is always actionable, and there is no necessity of statutory provision as such for preserving that right. But paragraph 98. But in a case where the life and personal liberty have been violated, the absence of any statutory provisions for compensation in the statute is of no consequence. Right to life guaranteed under Article 23 is the most sacred one. Then your lordship will kindly see paragraph 16, 15. Paragraph 16, my lord. We find the precedents for payment of compensation in a writ petition under Article 32 of the Constitution fall under three categories of cases. First, where the action of the commissions or omissions are attributed to the state or his officers, such as Nilavati Mahabharata, so all these cases have been there. So therefore, my lord, these actions and the official conduct of the officials are all the officers of the, and the, in view of the judgment passed by this court, we are required to follow the Sarla Verma case. If there are three factors are there, his income, family, and the age of the person, then the compensation as per the Sarla Verma has to be. Then your lordship will kindly see the Madras High Court case, they are very short. And it said the, 17 years died due to police torture in this case. As well also got this Madras High Court case 5259 2021. Yes. As well lordship got it. 5259/21. No. 5259/21.
Five to five nine, 21, 5 to 5 9. Fine, better. ये बात है
Yes. Yeah, my lord, 17 years. He has died due to police torture. Contention Sanjay Gupta was given in paragraph 7. When paragraph 11, my lord, Sanjay Gupta case followed. And paragraph 10, your lordship will kindly see. Five to 5/21, my lord, this like B, I think I believe. Like B. Of the bunch, huh? In the bunch, like B.
Sanjay Gupta.
Sanjay Gupta was followed. Sanjay Gupta, I have read this one. This is flag B, I think. I'll just show it to you.
Yeah, and there.
And there. May I read paragraph 1 now? Seeking compensation of rupees 50 lakhs. He is a person of 17 years, died due to police torture, did not have any income. Court has taken into consideration 21,000 as a income, and thereafter allowed payment of rupees 25 lakhs. May I read paragraph 1? May I? Yes, paragraph 1. According to the petitioner, she is the mother of the deceased, namely so and so. At the time of the occurrence, her son was 17 years old. The said deceased was working as a cleaner in Arts Move vehicle. Earlier on so and so, one Kalyana Sundaram gave a complaint alleging that some jewels were stolen from his house. In this connection, the police officers attached to the police stations have inquired about the theft, and thereafter the police came to their area and so and directed some person for attending inquiry. Based on the police instructions on so and so, the petitioner and her son Muttu, along with others, appeared before the inspector police stations, and the inspector interrogated them. Thereafter, on 8th, the petitioner's son went to so and so with regard to his work at Ramco cement factory. Thereafter, on so and so, the inspector of police attached to SS police station, sub inspector so and so and Ravi entered into the house of the petitioner without informing anything and searched for thefted articles in Almira, suitcase and other places at their house. After knowing that the said missing jewels were not in the house, they left. Thereafter, the petitioner's son cell number was not reached after 13/1/2019, evening to us. Thereafter, the husband of the petitioner rushed towards Panthalkundi area on 15/1/2019 to trace out his son since his cell phone was switched off. In the meantime, on 15/1/2019 at around 10 p.m., the petitioner's son called her and he could not speak. Therefore, the petitioners learned that her son was under some person's illegal custody. Thereafter, on 16/1/2019 at 3 p.m., a phone call was received from her son and insisted her to bring identity cards, school certificates, and other proof urgently. Therefore, she went to the police station. There, the sub-inspector of police so-and-so have obtained her signature in blank white paper, and thereafter the police have taken her son on the same day at about so-and-so to the government government hospital. Thereafter, at 7:30 p.m., he was produced before the learned judicial magistrate. At that time, the learned magistrate has informed the police to produce her son on 18/1/19 before the Juvenile Justice Board. Thereafter, only the petitioner came to know that on crime for the offences under section so-and-so was registered against her son. On the same day at around 9 p.m., when they reached home along with their son, he could not open his mouth and was struggling to speak and even struggling for normal breathing. Immediately, they have taken him to hospital for treatment, and the doctor advised them to admit in the hospital since he sustained multiple injuries and was having severe fever. At that time, her son told that one inspector of police, sub-inspector of police, so-and-so, and one Ravi, another police Ravi had taken him and they assaulted and thereby he sustained injuries. Further, her son was under illegal custody from so-and-so, so-and-so. And the doctor in the Vijay hospital informed that her son's kidney was damaged. Therefore, her son was shifted to government Radhaji Hospital, Madurai for another treatment. Accordingly, ultimately, he died on 24/10/2019. Last sentence. Then paragraph 6, your lordship will kindly see. On 24/1/2019, the petitioner preferred a complaint stating that there was a suspicion on the death of her son, and based on that complaint, CSR was issued after the completion of the investigation by examining 114 witnesses and 117 documents and 12 material objects. They filed final report for the offences under section 343, 304 IPC, and now it is pending trial. Since the case is pending before the court based on the outcome of the trial process, further action could be taken. Further, they filed additional counters stating that on 13/9/2021, this honorable court directed to send correspondence with the principal secretary to the government with regard to the issuance of compensation by then the additional public prosecutor. Accordingly, rupees 5 lakhs was paid. Your lordship got it. Paragraph 6. Then paragraph 6, paragraph 7, petitioner pays for rupees 50 lakhs. And paragraph 8, when the government says there's 5 lakhs is rupees paid, no further compensation. Paragraph 8. Paragraph 10, my lord, your lordship will kindly see. I'll read this. On perusal of the record. Paragraph 10. Yes. On perusal of the record, it is observed that the deceased is the son of the petitioner. The petitioner's son was taken into custody by the police against the crime number so-and-so. Thereafter, he was produced before the learned judicial magistrate number so-and-so, and then as per the direction of the learned magistrate, he was produced before the Juvenile Justice Board. And then she saw her son along with the police, and thereafter the petitioner came to know that her son was assaulted all over the body by the respondent police, and he sustained several injuries. Immediately, the son of the petitioner was admitted in a private hospital and then he was referred to the government hospital. In fact, the treatment was given to him from 18 to 24, and only on 24/1/2019 he died in the hospital. Thereafter, the first information report and the same was inquired by the police, and final report was filed as against some of the erring officials. In prima facie established that the fact that the deceased died only while he was in custody. So on the basis of the police report. Now paragraph 11. Coming to the quantum of compensation according to the petitioner, her son was working as a bookline cleaner and no any document was filed to prove the income of the deceased. However, for deciding the quantum, there is no formula for custodial debt. Therefore, this court safely follows the method adopted in MCOP cases. In this context, the learned counsel appearing for the petitioner also relied upon Sanjay Gupta case, which I have read, wherein the Honorable Supreme Court has held that the violation of life and personal liberty compensation to the victims to be computed in accordance with the principles of just compensation, as in the case of accident under the Motor Vehicle Act by the Motor Vehicle Accident Tribunal. It is admitted by both parties that the son of the petitioner was minor, aged about 17 years at the time of occurrence. So accordingly, my lord, the compensation was worked out and it came to about 22 lakhs, which is rounded off at 25 lakhs, paragraph 13. This is on the basis of the Sanjay Gupta case. Another Madras High Court judgment, my lord, Flexi.
Yes. R. Senthil Kumar.
Yes, ma'am. Here also custodial debt of the petitioner's brother. Paragraph 2, your lordship will get it, my lord. Paragraph 5, your lordship will get 5 lakhs compensation was paid by the government. And paragraph 14, your lordship will can see. Paragraph 14 and 15. 14, I may read, madam. As far as the third prayer is concerned, already police department have paid rupees 5 lakhs. The learned counsel appearing for the petitioner has argued that since the respondents being police officials have committed brutal murder and the deceased who was having tender age child and wife and adequate compensation has to be awarded. This court has power to award compensation for the custodial debt. In support of this compensation, he relied upon the judgment of the Honorable Supreme Court. The Nilavati Behra case, State of Odisha, and others wherein the Honorable Supreme Court has held that the High Court can award compensation for custodial debt by invoking 226. Further, in a decision of this court reported in so and so, in a case of Chairman Bar Council of Tamil Nadu versus State of Tamil Nadu, represented by so and so and others, this court awarded compensation for the assault made by the police by invoking provisions of 226. On paragraph 3, on careful reading of the judgment, it is clear that this court can award compensation by invoking Article 226 of the Constitution. Paragraph 16, according to the petitioner, deceased was aged about 26 years and no earning was mentioned in the petition. However, this court can take 15,000 rupees as income. In other case, 21,000 was taken as monthly income of the deceased. Accordingly, according to the Sarla Verma versus Delhi State Transport Corporation, the multiplier of so and so multiplier is 17. According to the case of the National Insurance Company Limited versus so and so, the future prospects for the deceased is 40%. Therefore, the income of the deceased can be calculated as follows. So accordingly, 28 lakhs 56,000 was paid. So 30 lakhs, paragraph 17. Your lordship, as regard compensation part, your lordship can see. Thereafter, the legal heirs, the mother, wife, and son of the deceased are entitled to compensation of rupees 30 lakhs. All the legal heirs of the deceased are entitled to 10 lakhs. Paragraph 17. 18. Mothers and siblings, 30 lakhs, and all the legal heirs, 30 lakh, 10 lakhs each towards compensation. They are also entitled to get interest of 6%, annum from the date of death. Paragraph 18,
Double 610.
till the realization of the amount. As a lordship got it. So interest was given, 30 lakhs was given to a person who did not have any means of income, taking into consideration 15,000 per month, and 10 lakhs to other. All the legal heirs have been given. And another Supreme Court judgment made, Sir Lordship takes. Supreme Court judgment, my lord, here it's a paragraph E, my lord. Khurshid Ahmed Chauhan, my lord. E. Like E. E.
E.
Let it be. Yes. There the facts is that your lordship will get it as 4.1. He was tortured in police custody. He was a policeman only. Therefore, my lord, an FIR was filed against by the police, then subsequently FIR was filed by the petitioner. Paragraph 4.1, the appellant is a police constable in the Department of Police who, at the time of the alleged incident, was posted at the district police headquarters, Baramulla, Jammu and Kashmir. On 17 February 2013, the appellant received a signal from so-and-so directing him to report to the office of the Senior Superintendent of Police on 20th February 23 in connection with their inquiry related to narcotics matter. The appellant alleges that no sooner he reached the office of the Senior Superintendent of Police, he was detained and subjected to brutal custodial torture for 6 consecutive days. His organs and testicles were amputated. Paper was sprinkled on his private parts and he was given electric shock which led to a fracture of his foot. This is the facts, Manda. And paragraph 28 you will also will can receive. As regard, he was tortured only. The counter FIR was filed at different matters, but ultimately, this court has, in a catena of judgments, consistently held that at the stage of considering a petition for quashing and ultimately criminal proceedings, which was initiated by the police, was quashed. It is not the function of the court to meticulously examine the truthfulness of the reason. Nonetheless, it remains a subtle principle of law that the allegations, even if accepted at their face value, must disclose the commission of constitutional offense. Paragraph 34 as regard compensation money. This is quashing is also there in this case. It was ultimately quashed when this part being. Paragraph 34, before we conclude, we deem it necessary to address the question of compensation to the appellant who is a victim of brutal and inhuman custodial torture. It is now well settled in Indian constitutional jurisprudence that where fundamental rights, particularly the right to life and personal liberty under Article 21 of the Constitution of India, are violated by the state machinery, appropriate monetary compensation may be effected, may be an effective remedy. D.K. Basu, this court held that Pecuniary compensation is an appropriate and effective remedy for the infringement of the fundamental rights caused by state officials, and that defense of foreign sovereign immunity is inapplicable. The court noted that such compensation must focus on the compensatory element and serve as a balm to the victim without prejudice to the other remedies in civil courts. The principle has been reiterated in Nilavati Veta and so on so forth. Ultimately, paragraph 37, 50 lakhs was completed. It is a case of torture. 50 lakhs was given. Paragraph 37. He did not die. It's an interim compensation. Paragraph 7, you are working in the line with the decision referred to above and in discharge of the court's duty to uphold the constitutional protections, we direct the state to pay interim compensation to the tune of rupees 50 lakhs. This is an interim compensation. Yes, in view of all these judgments, I'm not going through this 2019 Supreme Madras judgment. There I have they are also same thing, Mother. Compensation on the field of income. You take calculation to calculation. It is 50. We have given the calculation pattern. The Vijay Shankar case, is the copy of the judgment was handed over to your lordship.
Nilavati Bera is here,
Vijay Shankar
this comparison.
Hello?
Is that Nilavati Bera case here in your comparison?
Nilavati Vela is, I think, C. Yes. Is there. Yes. B much. This is 93. Is on the basis of district judge inquiry. At that time, 1.5 lakhs was given. Hello, may I just go through, take your lordship through the judgment? Division bench judgment of the Madras High Court as Vijay Shankar. As Vijay Shankar. Big bunch is there. Has your lordship got it? Just a minute. No, one more judgment. That this judgment. Once I again. Yes. Division bench. Yes. Sir. Vijay Shankar. Like, here also he sought compensation of 30 lakhs to be 35 years was, had died in custody, my lord. Paragraph, and he was a feeder. At paragraph 15,
1.5.
1.5. Internal page will be 13. 13. Internal page is 13. 1.3. Paragraph 15. It was on the basis of report. Initially, a case in crime so and so has been registered under section 174. Subsequently, the same has been altered to 176(1)(a). CRPC, after conducting a judicial inquiry, the learned judicial magistrate Kadalur has submitted a report on 16 before the learned chief judicial magistrate finding that the disease so and so was bitten by the inspector, then working in Nayavali town police stations and others. Charge sheet has been filed under section 2118, 218 and so IPC, and the case is stated to be pending in trial. From the above, it could be deducted that there is a specific finding of torture and injuries caused to the deceased Mr. Subramani, etc. This all happens in police station. Therefore, I am very afraid to go to that station, madam. Most of the people like me, we don't go to police stations. You do not know what they will do. Unlike the police stations of Britain. Copy of the report filed under section 176 of CRPC in Rashid has got good experience, madam. I don't have personal experience. My senior, one of my senior, he said they have the power to arrest. Be very careful with them.
people.
They are to task this to be developed. They must get the trust of the public as a whole. Well, then the copy of the report filed under section so and so 76 in the so and so is required for the purpose considering the prayer. And a principal judge Kadur is directed to send a so and so. Then thereafter, your lordship will kindly see page paragraph 16. When the matter came up on so and so, granted additional comment pleader appearing for the official respondent submitted that if this court deems it fit to consider this, that the state is bound to pay compensation to the family of the deceased Subramaniam who died in custody, then the quantum of compensation be restricted to ₹5 lakhs. He further submitted that if the quantum of compensation payable by the state is determined by this court, then the right to recover from the accused be given to the state. He also submitted that the state has requested Mr. So-and-so Learned Additional Advocate General Government to defend the case. Then the lordship will kindly see para 26. Para 26. On the above pleadings and submissions, the following points are framed for consideration. Whether the public interest litigation is maintainable for claiming compensation in the matter of illegal custodial death, torture, and when the affected party has a remedy to approach the civil court, and whether a public law remedy is a bar to claims also. In the absence of any method of calculation to arrive at the compensation, whether writ petition court can adopt the multiplier method. And ultimately, your lordship will kindly see page paragraph 74. Page 74. It's a very big judgment. Paragraph 72, your lordship make it. Page 160. Paragraph 72, married now. National insurance versus so-and-so. Paragraph, subparagraph 59.3, that not subparagraph, they have quoted from Sarla Bhima. While determining the income, an addition of 50% of the actual salary of the income of the deceased towards future prospects where the deceased had a permanent job and was below the age of the 40 years should be made. The addition should be 30%. If the age of the deceased was between 40 to 50 years, In case the deceased was between the age of 50 to 60 years, the addition should be 15%. Actual salary should be read as a actual salary less tax. Then in case the deceased was self-employed or on a fixed salary, an addition of 40% of the established income should be the warrant where the deceased was below the age of 40. An addition of 25% where the deceased was between age to 45 or 45 years. And second paragraph, my lord, for determinations of the multi-litigant, the deductions for personnel and living expenses, the tribunals and the courts shall be guided by para 30 to 32 of the Sarla Bhima cases. Accordingly, Paragraph 74, this is the amount calculated, giving a compensation of rupees 27 lakhs 79,000, whereas his prayer was only for 20 lakhs. Paragraph 74. Ultimately, my lord, your lordship will find that paragraph 76, 30 lakhs was there. Taking into consideration the payment expense towards funeral, etc. Paragraph 76. So in our case, my lord, 4 minutes. Lord, I have given a chart. I have given a chart, my lord, showing, taking into consideration his income, age and members of the family members. He is entitled to more than crores, 8 crores. 4 crores 80 lakhs. The lordship will kindly take into consideration here loan. Loan amount is shown at page annexure 11, page 119. Page 119, all bank papers are there. The loan was taken from the bank amounting to rupees 95 lakhs 55,683. And he was paying in vehicle installment of rupees 3 lakhs 59,000 590. Page 111, 119 to page 128. And his wife is there and his 2 minor daughters. No, it's a writ petition. Statement of account. This is the vehicle is there, right hand side, vehicle number. Contract date is 26/7/2019. And you are paying installment. Below your actual fine installment, above 6 lines, 7 lines, installment about 34 lakhs, 34,300. Similarly, page 121, another vehicle. Right hand column, you'll also will find product details. Vehicle number is there. And below, my lord, above three lines, the lordship will find 3 installments. Installment amount is 63,150. Page 123, third vehicle. You are paying installment amount of rupees 56,150. And next page, page 125, fourth vehicle. Yes, loan amount is shown and you are paying installment amount of rupees 67,990. The total comes to 3,59,000. Others are also there. Page 127. Paying amount of rupees 1,38,000 to our consuming. So therefore, बोल तो तुम्हारे 5 लाख টাকা দিবেন কেন কে খরচ করবে দোকান থেকে
এটা বুঝিবেন না।
ও হচ্ছে তো তো জোর আছে তাতে
আপনি রখাইতেছেন হয়ে আছে।
My conclusion, my lord, I have already given a chart showing the entitlement and the lot will take into consideration all the judgments I have provided.
My lord, yes, maybe, sir. Well, look, so far custodial death is concerned, my lord, it is not conclusively established that death was out of a custodial death, sorry, custody of the police, my lord. Still, criminal case is pending, my lord. That has not finally, my lord, determined. And my lord, at this stage, it is difficult to say, my respectful submission is, my lord, that the person died while he was in custody of the police. And the dead body was.
You will have to select your words very carefully because of the fact that it is the state police who has given the FIR and charge sheet submitted by the.
Yes, no, we are not supporting that, my lord, the action of the police officials who were involved. That we are not supporting because state itself, my lord, initiated prompt action, my lord. Also submitted, my lord, search sheet. That we are not opposing to that, my lord. So that is always there, my lord. And so far, my lord, that the compensation part is concerned, my lord, we have a policy, my lord. This policy is under Article 13(3) of the Constitution of India, my lord. So that policy is also not under challenge, my lord. That policy is there, my lord. Based on that policy, this honorable court has in other cases also, my lord, issued directions for payment of compensation, my lord. And apart from that, my lord, so far claim of the petitioners is concerned, my lord, that has also not been determined by any authority till that, my lord. And in this regard, my lord, I am referring to only one judgment, my lord. First. The policy to it, no? Policy can I call this policy? And it has to be replaced if it is considered a phrase, my lord. And as per the policy, my lord, the petitioner has been paid rupees 5 lakhs, my lord.
Not as per policy, as per interim order of the court.
is reflected in order 24/6.
And policy is also not under challenge, my lord. This. Okay. Yes, my lord. My lord. My. 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 357. No. When the court imposes a sentence of fine, yes, or a sentence including the so and so so, of which fines form a part and court may, when passing the judgment, yes. Yes. Right. Right. Now that is why my respectful submission is this scheme is, that is why in place. Madam. Madam. In the payment of any person compensation for loss or injury caused by the, when the compensation is, in the opinion of the court, recoverable by by such person in a civil court. Might. Can be recovered. Might. 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 After trial is over or other, after, might. But this scheme does not say, my lord, only of thereafter that can, my lord. My lord. Yes.
See the starting point of notification.
Yes, yes, yes.
This, in exercise of powers conferred in 357.
Yes,
of the
yes, yes.
so and so.
Right.
Now, here you see 357A,
Right.
no, capital A.
350,
7, capital A.
my lord. Small a, I think, my lord.
No, not small A, capital A.
After.
350 children.
Close 357, after that you will find 357A.
In defraying the expenses, my lord.
Yes.
Yes, that is small a, yes.
No, not small A. 357A, next page, turn over to next page. Ah. 357, capital A.
After conclusion of 357.
After 357 is over, you will get 357A.
Yes. Victim compensation scheme. Every state government in coordination with central government shall prepare a scheme for providing funds for the purpose of compensation to the victim for his dependent who have suffered loss or injury as a result of the crime and who require rehabilitation.
Yes.
Yes.
So you see, these matters we have dealt with in other matters.
Right.
Mr. Sharma would remember. You see, what happened was, the state government does not have adequate funds for this victim compensation scheme.
Right.
And then they came forward, we called them, the officials into the court
Right.
for this victim compensation, because all the district judges, or the DLSs in the state
Right.
were short of funds
Right.
when it came to the victim compensation scheme.
my lord.
Before we called the officers in one of the proceedings, and they told us that we have this year given a budget of, say, X rupees.
Yes.
Let
that
us
is,
say or assume,
Yeah, that's,
let us assume that they have given a budget of 10 lakh rupees.
my lord.
Then the fourth query was that does the government know that in this year there will be this many convictions, this many sentence, and this many compensation? So there is a budget of 10 lakh rupees. Because in these victim compensation cases, you can't have a budget.
My lord.
That no, this year 10 lakh rupees has gone, so the, any other victim will not get any compensation. So then the state government had done something to have this cap open.
But here, state has fixed the rate, my lord.
It's not a question of that.
My lord.
The question we have not got it. In Gauhati, next from today's 23rd of
April.
From 23rd to December 31, are you aware of how many crime will be there?
Certainly not.
You are aware how many victims will be, how many cases conviction will be there? In how many cases they will be sentenced? And what would be the sentence of money? You don't know? Can you have a budget now?
No.
And then say that, well, 10 lakh rupees we have spent, no more spending. Now we'll have additional budget, you will give a supplementary demand, and then we'll get that money and then we'll pay victims. That can't be the way. Because scheme is totally bad.
But based on this scheme, already given,
Not apply. Your argument has to be started. This is not, Mr. Das is not here after conviction and sentence.
no, my lord, scheme. Scheme condition.
On any extra college, sir, I have completed, I'm waiting for my license. Okay. I can inside.
They are waiting for their license, madam. They have already passed out. They passed out. They are from, I know she is from NCA, here, Arunachal, and where? Udalguri. They have passed their leave. They have all passed their leave. Tomorrow will call 10:30 and. Okay. Got that question?
So question is during pendency of the case, madam, whether that is covered or not. My lord. My lord. They will address. So what, as per my understanding, my lord, the criminal case has to reach the finality for getting compensation under this provision, as your lordship has said. But my respectful submission is, my lord, that is the present policy that is there in Assam, my lord, under which payment has been made. And the question, as now we are discussing, my lord, that we have to see it, my lord. Lordship has pointed out an important thing, my lord, that we have to, my lord, go into this one. Whether before reaching finality, even this will cover or not. Right. Now I have to respond it also. Right. Apart from all, my lord, even if direction is issued to pay adequate compensation, there has to be determination, my lord. So how it will be decided, how it will be determined, my lord. No appropriate authority has so far determined the claim of the petitioners, my lord. And so far action of the state is concerned, my lord, certainly state has done its part, my lord. And state is not favoring the erring officials, police officials, my lord. State and the person. Right. Right. Yes. They. No, certainly. But that we have not disputed, my lord. because the most important article 21, that is always there, my lord. My lord. My lord. Litigation. I'm only subject to, there is one judgment I am referring to, 2017 10 SCC, 658, paragraph 46. 2017 10 SCC. Page number starts from,
No. Citation page number,
my lord,
citation page number.
340, 658. 68, no, 658. Sorry, yes, 658. And operative portion is at paragraph 680, page 680, paragraph 46. Referring the decay basis case, my lord. May I read it? This court recognized that at the time of ratification of the International Covenant on Civil and Political Rights 1966, in 1979, the government of India made a specific reservation to the effect that Indian legal system does not recognize a right to compensation for victims of unlawful arrest or detention, or only became a party to the covenant, subject to its reservation. It is noted, however, that reservation has lost its relevance in view of the law laid down by the court in several cases wherein compensation has been awarded for the infringement of fundamental rights of a citizen. It was also noted that while there is no express provision in the Constitution for grant of compensation, this right has to be judicially involved in case of established unconstitutional deprivation of personal liberty of life or life. This summed up the law following the words. Thus, to sum up, it is now well settled proposition in most of the jurisdictions that monetary or pecuniary compensation is an appropriate and indeed an effective and sometimes perhaps the only suitable remedy for redressal of the established infringement of fundamental rights to life of a citizen by a public servant, and the state is vicariously liable for their acts. The claim of the citizen is based on principle of strict liability, to which the defense of sovereign immunity is not available, and the citizen must receive the amount of compensation from the state, which shall have the right to be indemnified by the wrongdoers. In the assessment of compensation, the emphasis has to be on the compensatory and not on punitive element. The objective is to apply balm on the wound and not to punish the transgressor or the offender, as the awarding appropriate punishment for the offense, irrespective of compensation, must be left to the criminal courts in which offender is prosecuted, which the state in law is duty bound to do. To award the compensation in public law jurisdiction is also without prejudice to any other action like civil suit or damages which is lawfully available to the victims of the heirs of the deceased victim with respect of the same matters for the tortious act committed by the functionaries of the state. The quantum of compensation will of course depend upon the peculiar facts of each case, and no straitjacket formula can be involved in that behalf. The relief to redress the wrong for the established invasion of the fundamental rights of the citizen under the public law jurisdiction is thus, in addition to the traditional remedies and not in derogation of them, the amount of compensation as awarded by the court and paid by the state to redress the wrongdoer may, in a given case, be adjusted against any amount which may be awarded to the claim by way of damages or in a civil suit. So leaving aside everything, my lord, if it is decided to compensate, my lord, in consideration with their claim, there has to be a my lord, specific decision by any appropriate the authority or the court of law. It is not my submission that public remedies is not available for the petitioner. It is
What the timing on the date for
Detail you can-
date? Next week.
compensation দিবলে কৈছে compensation দিবলে কৈছে Thank you for this.
You cannot arrest. No. Without information.
Going to page 680 and 681. In that case, there is a reference to this Nina Rajan Pillai. In that case, this is the data. It's only of Delhi at that time. This is the data in this case given at page 48, para 48.1. In Delhi, this is the number of deaths.
That in judicial custody, yes, natural and.
Correct.
Right.
Now, in this case, the last part you will find, compensation of rupees 10 lakh was issued in this case.
10 lakh.
In this case, the Nina Rajan Pillai, 48.1
Right.
of that paragraph of your judgment cited.
Right.
The Delhi High Court judgment.
That is the question, my lord. That whether he died out of.
That you don't know how to argue.
Yeah, but it's in the area, the friend.
Yes.
Yes. May I refer also to the judgment of DK Vasu, my lord, paragraph 54,
DK Vasu.
my lord. Open a copy.
DK Vasu. DK Vasu will be.
Yeah, nice to be back. Yeah, I think.
One is-
Yes, sir. Yeah.
Yes.
Paragraph 54, my lord.
The one which is quoted here. The one which is quoted in the earlier. document.
It is
Yes.
here also.
That. 54, yes. Again,
Have
I-
it here. You can read from this only.
My
This is quoted in that paragraph 47.
54,
Paragraph 46.
yes, yes.
Yes.
So, my lord, I am not submitting that he is not entitled to the compensation. That is not my submission. But how it will be determined? Which authority will determine? Some authority has to be determined, my lord. So far, claim of the petitioner is concerned,
No, you see this, when you are citing this, DK Basu,
my lord.
can you please come to paragraph 43 of that?
Yes, 43. Go ahead. This is still about 2 decades ago, that matter. The liability of the government for tortious acts of its public servants was generally limited to persons affected could enforce his right in tort by filing civil suit, and there again the defense of foreign sovereign immunity was allowed to have its play. For the violation of the fundamental rights to life or basic human rights, however, the court has taken the view that the defense of foreign sovereign immunity is not available to the state for the tortious act of the public servant and for the established violation of the rights granted under Article 20 of
If you
1 of
stop
the.
here for a moment,
My lord.
the defense is not even available to the state.
No. I'm also not
No,
that,
but that, the civil action,
my lord.
you proceed.
Not clearly because of civil action, state will abstain from, my lord, granting compensation. That is not there,
That's very important. We stopped here for a reason.
my lord.
Now you see after that. Mere punishment.
Paragraph 14 to 43, my lord. 43 in the, yes. It is not available to the state for the so for the established violation of the right guaranteed under by Article 21 of the Constitution of India.
Yes.
In so Nilavati Behra versus the decision of the court so within the plea of
Now come to para 44.
my lord. The claim in public law for compensation for unconstitutional deprivation of fundamental to life and liberty, the protection of which is guaranteed under the Constitution, is a claim based on strict liability and is in addition to claim available in private law for damages for tortious acts of the public servants. Correct, my lord. I am not disputing this, my lord.
No, after that, you see this.
Public law
44
proceedings
is
serve a
very
different purpose than the public law proceeding. Award of compensation for established infringement of indivisible rights granted under Article 21 of the Constitution is remedy available in public law. Yes. Since the purpose of public law is not only to civilize public power, but also to assure the citizen that they live under a legal system where their rights and interests shall be protected and preserved. Grant of compensation in proceeding under Article 32 or 2226 of the Constitution, therefore the established violation of fundamental rights granted under is an exercise of the court under the public law jurisdiction for penalizing the wrongdoers and fixing the liability for the public wrong on the state which fail in the discharge of its public duty to protect the fundamental rights of the citizen.
And next again.
The old doctrine of only relegating the aggrieved to the remedies available in civil law limits the role of courts too much as the protector and custodian of the indivisible rights of the citizens. The courts have the obligation to satisfy the social aspiration of the citizen because of the courts and the law are for the people and the expected to respond to their aspirations. A court of law cannot close its consciousness and aliveness to stark realities. Mere punishment of the offender cannot give such solace to the family of the victim. Civil action or damage is also a long drawn and a cumbersome judicial process. Monetary compensation for redressal of the court by finding the infringement of fundamental right to life and citizen therefore useful at time perhaps only the effective remedy to apply balm to the wounds to the of the family members and this is victim who may have been the breadwinner of the parent. Right. We are not disputing, we are not opposing with regard to the duties and responsibility cast on the state, my lord. State has to, my lord. But how it will be determined? Whether the notification already issued to that effect, my lord, is also applicable pending trial of the, my lord, person accused, my lord.
You have to show us, we can't read something into a notification which is not there.
My lord.
You have to show us that.
Because,
read this notification to
my
think that interim compensation can be granted under 357.
yes, we have already paid, my lord, 5 lakhs of rupees. Yes,
Payment is something else.
my lord. Yes,
But they have a large budget, we make payment for, even for not procuring an item, you can make payment.
my lord.
If you are not on that. The fact is that you will have to make a submission and
Right.
record it,
My lord.
that the additional advocate general argues that 357 can be paid as an interim
Yes.
compensation. We'll record that.
My lord. Right. Even, yes, I understand. Not that,
We can't, otherwise we can't read it to a notification that it could also include the interim payment.
yes, that is,
But if a law officer argues, then definitely we'll take into cognizance.
yes, like you. I will be competition of both motivation of Village Activity. 271. Notification हो शायद complete हो तो देखिए applicability to I think, my lord, they when accept this notification, to that effect, other notification that is not there.
No, you have a notification. You're just not.
Yes, I'll try to find it out.
No, no, it is there. We have it. We have a copy of that. That's.
Fifteen compensation account notifications was not written with the letter. Twenty-two.
Close to in excessive power under subclause 9 of Assam Victim Compensation Scheme.
Yes.
1922.
Yes, this is your notification.
1922, I think.
This is,
22 is of the bill.
no, this is 1st February 2019.
Then there is another, I think, 22. So what?
22. Ah, yes.
22.
Yeah.
22 you can put.
Both the same.
They've increased the amount.
Some.
But
But
pursuant
you know,
to-
this notification is again very interesting. We'll show you. Let it come to me, I'll show you. It is very interesting.
No, I think I have read one.
No,
This is also, my lord, the Assam Victim Compensation Scheme 2012.
yes.
2012, my lord.
So that's,
Pursuant to this,
look at the heading.
Yes.
If it is police death, the amount is 3 lakh rupees.
Yes.
But otherwise, if it's a person dies, it is 4 lakh rupees. So therefore, if a policeman kills someone, compensation is less.
Yes.
You have noticed it?
1st February 2019.
And there is another
That-
provision too, that is on the right side. So we have it.
22 SMS. What will you do the thing? Will you do the thing?
Police is 3 lakh, otherwise it is 4 lakh. You know.
Police.
But we have it. You
Yes,
give us, we have
We,
it.
we'll try it.
No, he gave me. We have it. Mr. Das has it. Mr. Das, don't worry. We have it here. Mr. Das has it. Take it from him.
Two 2019.
Now, the amount you see in police,
Oh, yes,
that is less,
my lord,
and otherwise it is high.
my lord.
So the government wants to comply, otherwise then action.
Protecting their right.
Well, that we have. 19, that is 19.
Then thereafter 22 is also.
It is right side.
Yes, asking them, actually. We are aware of that. How this is no way connected with that case, with the present case. They cannot override the judgment of the Supreme Court. Supreme Court has laid down clear guidelines.
Death due to injury or quarrel among the police. Death due to injury, torture, beating by the prison staff. Death due to negligence and duty by prison staff. Open independent bill. This is victims of the prisoners. 22 big notifications. And 1st February 2019,
After the 22.
that is also in terms of the scheme, my lord.
No, but this is victim compensation scheme. That's again, I got 357A.
Which you mind of 2019 one. In exercise of power conferred under subclause 9 of the clause 5 of the Assam Victim Compensation Scheme 2012,
Assam victim
that is the motivation.
Yes.
Statement, and in persons of the order of the Honorable Supreme Court in WPC so petition number so the Governor of Assam is pleased to amend the schedule for Assam Victim Compensation Scheme 2012 by revising the quantum of compensation awarded in the said scheme as below. I think for all practical purposes, my lord, that has been treated compensation for the, my lord, the victims. Not only in respect of, as we understand, my lord. 7, except this notification, I think no other is there. Even then, I will try to find it out, if any, my lord, notification is there other than this.
Court of
Total. Arresting. That was an arresting. just something, এই যে পয়সা তুমি দিতে কি হয় না দিতে। পয়সা দিয়ে দিতে।
We try to find out this.
My God,
867.
I'll be able to be. One communication. Hmm? I go to order. I don't know. I go to order. এই কথাটা question. এই কথাটা question. Hmm? এটা revenue and heading নাকি? এটা revenue দিয়ে heading কি কোন ডিজাইন কোন করছে? ড্রাফট করলে কি কিন্তু রেডিওর কথাই আছে পার্ট ওয়ান পার্ট টু
Mr. Goswami, you're relying on?
মাই লর্ড
Anything else you are relying on?
and that's the judgment I have referred to him as I have
DK Basu,
DK also and other one
in UN. We already noted that.
other judgments as referred to my learned senior my lord that has been single bench of Madras High Court I think not other than those courts.
He has given a bunch which has many judgments.
My
Five
lord,
or six judgments are there,
my lord,
and then there's that Madras, and then is one more.
my lord. Hmm? In the affidavit also nothing is clear with regard to scheme, my lord.
Fine.
In our affidavit, in this regard, nothing is clear, my lord. এখন নোটিফিকেশন তোমার সদ্য এখন তো কি বেরোত না গভর্নমেন্ট বেলেগ না Look, Mayor, my lord, Lord, you could kindly have it look, my lord, annexed to the affidavit in opposition,
Affidavit in opposition.
my lord.
Yes.
Okay, yes. Only one affidavit, I think, that is filed by F1 number 2.
Five. There's only one.
In paragraph 12, they say, well, no provision for granting compensation. That is the only relevant question.
May I read it, my lord? Annexure name. Annexure name. Huh? No, that name.
No, there's only one affidavit here.
Yes, by respond number
By
2,
respondent number 5.
who is there? Also, dear, madam?
By Mayank Kumar, IPS.
Tapas Gupta,
No,
Deputy
never
Secretary,
filed.
Government, Home and Political
No,
Department.
you may have it, but it was never filed. Our record does not show it. Mr. Das, you have been
No.
served with it.
Only respondent number 5 and the relevant paragraph is paragraph 12. It
No,
says,
his.
No.
Additional.
no,
No, let us allow to verify it now.
It's not there.
Because
if you have-
I am
No, no, if
submitting.
you have filed it, you must have served copy to Mr. Das.
Yes, yes,
It's not there.
certainly. Yes. Well, you can put any. Well, let us verify, my lord. Because, my lord,
That's not here.
Have to find it.
maybe you can put any.
Find it.
What you have to say, just shows that document, you can set up.
Yes, mother,
Yeah.
I found it, my lord, notification, under notification, that is 15 November 2014, my lord.
14.
Yes, notification. The governor of Assam is pleased to revise the quantum of relief in respect of person killed, so and so, so
No,
and so,
that
so
is
and so.
14 is passed.
The
After
notification,
1419.
my lord. That, 14, my lord.
Passed.
Not under.
No.
Not under the screen. Let's take a look. We have it.
My lord.
We have it.
Yes. So I think it is
Sir.
independent to that.
Mr. Nath, in one of the matters has provided us with this, we have kept it in this file and then we have.
That is there, my lord.
We have it.
Yes.
The affidavit is not there, but the.
Yes,
How to know
that
this?
notification is there. I think this is not in terms of the provision of this scheme. It's an independent one.
In relation to extremes.
Extremists, terrorists, miscreants. The killing is not a result of private dispute.
Even in this case.
No, my lord, nature of incident that has been referred to, my lord, one, ex gratia gun to NOT, the person's killed and whose the person's age is 18 years or above. Number one, by extremist, by terrorist, miscreants, when as per the report of the police, comma, the killing is not as a result of private dispute. This is not a private dispute, man. Killing is entered here.
Yes, they are saying that killing.
During communal violence, communal
They are saying
ethnic,
their own officers are extremists.
no, no,
That's what they are
no,
saying.
no, not. No, what he has said, my lord, that's right. By extremist, stroke, terrorist, stroke, miscreants, when as per report of so and so,
No, you
comma,
Mr. Goswami,
my lord.
this is the notification I was referring to when I said that when security forces kill, you get less
my lord.
You see
Oh,
here,
that part, my lord, because state, it's a action of the state, that part, certainly, I'm not saying, my lord, in that part, but what is there in the column that I am only reading.
no, you see,
Just need
police,
to-
the,
I don't think so, other people will come. Here you have to apply a distinct element. Only extremists, terrorists, those category of person.
And
not the.
comma, the killing is not result of private dispute. My lord, in a clause, police will kill someone and will pay compensation, that will certainly be not there, my lord, in that case. But that is there, the killing is not as a result of private dispute.
This also doesn't cover police.
Also, due to the firing of security force, all these things are there. Three, due to firing security forces, if the person is killed innocent as per report. Who killed, injured due to extremist violence, terrorist violence, acts of miscreant, communal violence, ethnic violence, group clash, firing of security forces, accident, etc., were kidnapped.
So this is, it's not there. This is something which we are aware of.
My lord,
This is something which we are aware of. This doesn't cover police action.
I think other than these notifications,
And what do you say about quantum of compensation?
that part, my respectful submission is to come to a conclusion as regards quantum of compensation, my lord. Some authority has to, my lord, come to a finding in that effect, to that effect. Because it is difficult to decide by disseminate court to that effect. That I am submitting, my lord.
Some other report?
My lord, some authority has to, my lord, look into this, my lord. What will be the quantum, my lord?
We don't know whether you are aware of not, but in our High Court, we have developed a format
Yes,
for MSCT cases.
my lord.
You just have to give the age, you have to just give the income, and next time when you open a Gauhati High Court website, you can have the MSCT calculator. He'll give you. You don't have to go anywhere. I can even ask my court master, and my court master can give you quantum right now. You give him 20 minutes, he will give it to you.
That, of course, I don't know.
We have developed it.
That I don't know.
S.K. Gupta case has already stated how the quantum is built. Matlab 97 Basu case, paragraph 45. Matlab, it has started, matlab,
No, but somebody has to do it.
yes,
We have formulated.
now the thing is
We have formulated everything into what you call a multiplier.
yes,
We have
automatically
made
it
it
comes.
and we have put it in the website. So if you want to know what compensation you want, you can just go to our website, open it, do the calculation, and you get it.
That is it. Otherwise, matlab, Sanjay Gupta says Sarla Vardhan. It has not been,
For parameters.
yes.
you
So-
write,
Earlier, matlab, the compensation part was left, it was more or less lump sum. And subsequently, my lord, in the DK Basu case, paragraph 45, it stated clearly that we used to send the matter to the civil court, but that is not good enough. Ultimately, justice has to be done. So therefore, my lord, the court said, we'll have to give some compensation. So ultimately, my lord, DK Basu says you go to, you take the ratio of the Salavan formulas, MSCT cases.
No, DK
So-
Basu doesn't say. DK Basu is first in point of time.
Huh?
After-
Sanjay Gupta, sorry.
Behra.
Sorry, Sanjay Gupta. Sanjay, Nilavati Vehra also that public law remedy, it says 91 Supreme Court. But DK Basu also says, what is the point of relegating the matter to the civil court?
No,
We'll have to
no,
give
no.
certain. Paragraph 45. DK Basu says paragraph 45.
No, see that.
I'll just, it says, there is no point sending the matter to the civil court.
Escape.
DK. Paragraph 45, your lordship, permission. Ultimately, Sanjay Gupta, it says, follow.
Reflecting this. Reflecting this. That was neither. 45. Reflecting in this.
Oh, so correct, ridiculous. It is reflected here.
It is there.
Huh?
Remedy is available in civil law.
Yeah.
In that, we will also. It's not pretty, no.
Good. Then the quantum analysis came in Sanjay Gupta case. No, before that it was not. The Sanjay Gupta case, the first. And the Supreme Court, my lord, in that my lord, torture case has provided.
Development. Quite good.
Mr. P.D. Das, Learned Council, assisted by Mr. R. Deka, Learned Council for the petitioner. Also heard Mr. B. Goswami, Learned Additional Advocate General, assisted by Mr. R. Bora, Learned Additional Senior Government Advocate, and Mr. P. Sharma, Learned Additional Senior Government Advocate. Submissions are concluded. Order is out.
My lord, I am also assisted by D1000 and Mr. Lotha.
Just give the name, family, right? Just write the name.
Deeply.
So method is already in place, my lord. The quantum, fixed quantum, my lord.
I did not get it. Please repeat again.
The method of, my lord, calculation, my lord. That is quantum. So far, fixation of quantum is concerned, my lord. Your lordship has,
No, that is MACD calculator we are saying.
acha.
We are not saying about the custodial death. We are saying about that. Mr. Das was saying about the that
Right.
calculator and the judgments. We have said that we have all these judgments we are having.
But correctness of his claim, that has to be decided some authority.
Supreme Court has already laid down, that's what I have been
No,
submitting.
his claim particularly, facts of the case, is it factual metrics?
That is for us to now decide.
Yes,
Your argument is over.
all right, at least to understand this matter,
Deeply.
of like.
Time being item 3 for motion.
My lord, verbal instruction received lordship, actually, they did not provide us the copies lordship, so lordship written instruction did not receive it, and my verbal instruction says that lordship on 10/2/2026, the person concerned has already been expelled lordship. So, yes, lordship.
Send back.
So we have already given copy, another copy will give. We have given.
I did not receive, I checked the record also.
We'll provide one copy, we'll provide one later. Oh, copy issue. What?
Among the,
Oh. Pero no koy provide ko. Oh,
I
while
have
filing,
one
we have
copy. I have
provided
one
copy. While filing, we have given copies. If the cost. As per my instruction, he is telling he has provided. Copy.
That's so copy to send, yes.
Receipt is, receipt is. We have received.
Extra copy দিদি মা।
Maybe it has been misplaced. If they insist, I will give. Yes, ma'am.
এমএন কৰিছানে? এমএন কৰিছানে ইউনিয়নৰ নামটো?
এতিয়া এটা মেয়ৰ
Number.
10 to 2026. 26. So Koriমগঞ্জ. I think Lordship state authorities handed over to BSF Lordship and BSF authority so that would not okay to delay. Mumbai.
Twenty-nine. Monday is 27. No, the Lordship is saying Monday or. 29 we can try. Or in that case, Lordship on 6th.
Highly obliged. Yeah.
Time being item 4 for admission.
Well, the pursuant to Lordship's last order, I have received some instructions. Well, this is the first is Malad, I have paginated. First is the minutes of the review meeting held under the chairmanship of the Chief Minister, Honorable Chief Minister Malad. Here, some decision has been taken as regard the implementation. There is a scheme, Malad. Deen Dayal Divyangana Purna Samsthapan scheme. Kindly see Malad serial number 6 and 7. in this minutes. So all, this scheme provides for some training. And I'll take your lordship to the eligibility for having the benefit of that particular scheme. Then kindly see my lord page number 3. On 31st of August 2022, as per the decision of that minutes, the committee has been notified for implementation of that particular scheme, and they are the chairman and the members of the committee. They will monitor implementation of the scheme. Then page number 4, the guideline for implementation of the Deen Dayal Divyangjan Punasangsthapan Asani. There, lordship will see earlier one time 10,000 rupees was given, then it in view of the scheme of the 1819, it was enhanced to 20,000 in the second paragraph. Lordship will see that the scheme has been modified and now proposed to be implemented in collaboration with Assam Skill Development Mission and Directorate of Employment and Cross-Line Training, Assam, aiming to provide skill-based training to the beneficiaries in place of financial grants. So that has been modified, and comprehending that skill development can reduce and underemployment, increase productivity, and improve standard of living. So I'll take your lordship to the scheme also. So to get the benefit of this scheme, eligibility criteria has been fixed by the guidelines. The applicant eligibility criteria is provided that applicant must have UDID disability certificate issued by the competent government authority of health services. The person must be within the age group of 18 to 45. The applicant must be a permanent resident of Assam. That person should have minimum qualification of class 8. Then annual income should not be more than rupees 2 lakhs per year for the individual. Income certificate of the circle officer to be enclosed. Then mechanism has been provided. Implementing mechanism, page number 5. A district level selection committee under the chairmanship of the deputy commissioner shall be constituted, comprising following members for proper implementation of the scheme. Deen Dayal Divyangjan Punasangsthapan Asani. Their DC, District Development Commissioner, has been made chairperson. Then District Development Commissioner, District Project Manager, Training, Assam Skill Development Mission, Nodal Officer from Directorate of Employment, and the District Social Welfare Officer is the member secretary. The Director Social Justice and Empowerment Assam and a District Social Welfare Officer will widely publicize the scheme. The District Social Welfare Officer shall act as nodal officer for implementation of the scheme in the district. The application form shall be obtainable free of cost from the local offices of the District Social Welfare Office. The District Social Welfare Officer will receive applications submitted by the applicants for the scheme. So the intending applicant fulfilling the eligibility criteria has to submit the application before the District Social Welfare Officer. Then after scrutiny of the applications, she will convey meeting of the district level selection committee, which is competent authority for the verification of the contents of the application and selection of the beneficiaries as well. Then accordingly, they will select and provide the benefit. The District of Assam has been placed in 4 regional divisions. This particular case from Bongaigaon, it falls under Lower Assam at P6 now. Then for implementation of this particular scheme, a memorandum of agreement has been entered into by the Directorate of Social Justice and Empowerment Assam with Assam Skill Development Mission. At page 8, it is available. This memorandum in detail provides all the responsibility of the directorate, the responsibility of the Assam Skill Development Mission, then funding, everything, how they will provide training, they will engage training provider, Accordingly, training will be provided to the selected beneficiaries. This is the entire scheme they have given. So this is the only scheme in respect of the disabled persons as on today. Then kindly come to page 13 of that part. But they have said that the government has also constituted an expert committee to identify posts for benchmark disabilities under the various departments, which was formed by government order number so and so dated 27/6/2025. However, the Department of Social Justice and Empowerment is not competent authority to put any individual in the engagement in semi-skilled or unskilled job, unskilled working. Semi-skilled or unskilled. Lordship. But ultimately, you know, from the memorandum of the government of the department and the mission, but I could find that they will ultimately engage some training provider. Training provider will be the NGO, as Lordship has indicated, some specialized agencies, they will come and they will train up. They will give them some. No, it is. That's true. That's true. Here now he is about 24 years of age. And he has also passed HSLC, you know. So to an extent, you know, his qualification is also there, and otherwise he falls under this scheme because he has passed 8 and some.
Yes.
No, but if Lordship kindly, that Lordship has taken note of all of in Lordship's order dated 18/2/2025 and subsequent order 4/3/2025. Then in the order dated 27/3/2025, Lordship has taken note of. I'm reading the relevant portion of order, Lordship's order dated 27/3/2025. Right? First, kindly come to 18/2/25. Lordship. There, the Lordship has recorded that the medical document, the second paragraph, the submission of the learned counsel for the petitioner remains inconclusive. The medical documents of the alleged victim reveal that he is suffering from mild mental retardedness, which is diagnosed by the medical board. Accordingly, this court inclined to request the standing counsel of the health department to inform the court as to the standard protocol for patient of such nature insofar as their medical checkup is concerned. Then in the next order, Lordship has recorded report has been called for. Then in paragraph 3, Lordship has said that it has come. So the report says that from the said report, it appears that the medical opinion is to the effect that most of those in the higher ranges of mild mental retardation are potentially capable of work demanding practical rather than academic abilities, including unskilled or semi-skilled manual labor. Then, so this court is of the considered opinion that the superintendent of Gauhati Medical College and Hospital be requested to constitute an appropriate medical board to examine the victim, namely so and so as they assess as to whether he has the potential and capability of unskilled or semi-skilled work to explore the possibilities of his rehabilitation in the society. Subsequently to that, Lordship kindly come to 27/3/2025 order. There, Lordship has recorded, para 2, pursuant to the order dated 4/3/2025, Standing Counsel for the Health and Family Welfare Department has produced a copy of the written instruction dated 20th of March 25 along with the medical report of Sri Chandeswaran Roy. On perusal of the said medical report, it appears that the victim at present has no major neurological deficits. However, his Vineland social maturity scale score was 58.3, which is suggestive of mild mental retardation. As per the said report, the victim has potential and capability of unskilled or semi-skilled work, and as it has suggested that he may put in such semi-skilled or unskilled vocation job for rehabilitation. But under that, considering this, in these developments, Lordship has directed us that as to whether there is any scheme for his engagement in any vocation of having unskilled or semi-skilled the vocational job for rehabilitation. Is there any scheme under the government? That Lordship is one of them. We have also inquired from the department. So the department has said that there is a scheme for training and all. but direct engagement in a particular job, that is not there. And what I find from the scheme also, Malan. Logic. Malan. This is below average or low range. Logic. Well, I'll just refer to the revised guideline once again. The page 4, in fact, initially this scheme, our scheme of Dindal Divyangajan Punarsamsthapan Asani, it was one of the initially 10,000, subsequently 20,000. That was as one-time grant who endeavors in running a business of self-employment but needs financial support to go ahead. So that was the purpose. Ultimately, we have to one of the give them small shop, logic. Below average. Look at it, logic. So
24 years now. Yes. Yes.
there is no chance of growth for us. In fact, while referring to this scheme, I have referred to this, but that doesn't, well, ultimately the government found that that doesn't work. Therefore, the government has now switched to this particular scheme of giving them training for by the special agencies. But something has to be done. Well, this particular person here, he has, what I'm indicating that he is HSLC pass and having a disability certificate. The grade 4 for grade 4 post he can apply, because that for that particular category of disability, some post is available. Post is earmarked ultimately to get a government job or regulation vocation. He has to respond to the advertisement. Otherwise, he is qualified. The HSLC qualification he is having, and the certificate is also for more than 40% disability he has. So disability certificate he is having that certificate. So that advantage he will get. Coupled with that opportunity which is with him, and this under the new scheme also, if he is having disability certificate of 40% and above, he can avail the training. And here kindly see, therefore the provision has been made at serial number 9, serial number 9. This is the part of the memorandum of the agreement. The responsibility has been given to the skill development mission, that they will provide skill training, assessment, certification, placement engagement, and conduct post-placement engagement, tracking of the candidates through ample and training providers. So that provision has been made. So that is what I have indicated. Kindly see, the, that is, well, page number 5. Page number 5, huh? Implementing mechanism. There is a district level committee, there is a district level selection committee. He goes to Lower Assam. So the concerned district social welfare, that after 1, 2, 3, 4, 5, the members and chairperson, members and member secretary, there is a paragraph. The director social justice and empowerment Assam, the district social welfare officer will widely publicize the scheme. The district social welfare officer shall act as nodal officer for implementation of the scheme in the district. Application forms shall be obtainable free of cost from the local officers of the district social welfare office. The district social welfare officer will receive applications, submit the applicants for the scheme. After scrutiny of the applications, she will convey meeting of the district level social selection committee, which is competent authority for the verification of the contents of the application and selection of the beneficiaries as well. So he has to apply for that.
Yes, Manoj. Yes.
I have given it. Yes, yes. Yes, yes. But what I am indicating, he has two options. One is the recruitment processes are going on. If any recruitment process comes up, he can very well with the application, he can apply for the post disability category. And this is a scheme there he will be given training and he can also have avail the training so that any future prospect or he can choose or he can participate.
Yes, Manoj. I have to take.
Yes, yes.
Yes. They are from the remote area. Yes. Yes.
Not, otherwise, this scheme he can apply. His application will be considered accordingly, and let him take the instruction. And Lottie was also directed for interim compensation. I'm just indicating that small shops or anything business for his survival, he can also utilize that fund for that also. Yes, yes. Yes.
Your lordship may
Otherwise-
also interact with the boy also, if permit. Manoj. Your lordship may interact with the boys, Manoj. Boy. Yes. Yes.
But yes, sir. Mhm. In fact, Prahlad, these things are going on to help a person who is in need, not on merit, Prahlad. Otherwise in merit it's a different case. On merit it's a different case, Prahlad. Got you, Lordship.
Yes, Manoj, I will take instruction.
Yes. Yes, yes, let him take, let him take.
Yes,
I have
I
given,
have already.
I have given.
The state of Assam has been divided into 5 regional divisions in connection with Deen Dayal Divyangan, DIVYANGJAN, Punar Sansthapan, PUNORSANSTHATON, Asuni, ACHONI, a rehabilitation program for skill development training to youths with disabilities. And as the petitioner is a resident of
Bongaigaon.
village number 1, Nason Khuti, NACHONAHUTI, under Bongaigaon district. The petitioner would fall under the jurisdiction of divisional headquarter under the Lower Assam division with headquarter at Gauhati. Next, a copy of the said bunch of documents has also been provided to the counsel for the petitioner. Next para, we adjourn the matter to enable the learned counsel for the petitioner to obtain instructions to inform the petitioner about the said scheme and to obtain instructions regarding the whether the petitioner would be interested to allow her son to take benefit of the said scheme. What's the problem? If the petitioner would be interested, not allow, be interested in her son taking benefit of those schemes. Next para. List again on by when, Mr. Kalita?
My lord, second week of May, 12th of May.
Okay, 12/5/2026. We
Hello.
don't have a special bench on that day.
Well, in Lordship's order, also kindly note page 13 letter,
Page 13.
13 letter of the secretary. Otherwise, Lordship's queries, agricultural schemes and scheme and all, this is the information given by them.
Huh?
Lordship's queries regarding scheme. And this is the reply given by the department at page 13. Lordship will also indicate this also. Take note of this.
Not the rehabilitation.
No.
Okay, we take note of that.
No,
Just remind us on the next date also
Lord,
that rehabilitation may not be possible by the state.
my lord.
Okay, just remind us.
Yes, yes.
We, in today's order, we don't want to put that in the negative so that the petitioners get disheartened.
Okay.
Just remind us on the next date.
What?
In this case. Mr. Kalita, if you don't understand anything, just take some time from him and then ask him. Be able to. If you read it, then find some difficulty. That
Well, can I just pay for 13th or 15th if not inconvenient?
13.
13th.
13 the full- 13 the motion to 14.
14th. Lot. Publish.
Other matters may not have time to take it up.